Hey guys, today I'm going to talk to you about what I started yesterday. I just didn't have it in me yesterday to talk about the loss, to talk about the fact that my client was going to prison, for 3 years. It was difficult. The good news is that I actually can speak about the facts of the case because the client was nice enough to sign a waiver of confidentiality. However, I will not use their name. So we're just going to say Mr. Smith. So ultimately, Mr. Smith was charged with domestic violence. Obviously a real serious topic. The allegation was that he choked and put his significant other, his wife, into a chokehold, and then also put her in some sort of like karate type movement, jiu-jitsu type movement, where some sort of arm bar. The allegation was that they had a fight over social media, and that ultimately the argument turned physical. And during that time, there's allegations that he pushed her, hit her, choked her. So, and also that he pulled out a gun and put it to her, saying that he was going to kill her. During the course of this, there was an allegation that a child that was in the other room came out and saw the violence with the gun and asked his father whether or not he was going to shoot mommy. That was the allegation. So obviously some pretty strong allegations. Ultimately, my client was charged with aggravated assault with a firearm, aggravated assault with a firearm, domestic violence battery, battery by strangulation, and also false imprisonment. That was the first set of cases, the first set of charges. The false imprisonment was an allegation that during the time that all of this was going on, police apparently were outside, and he prevented her from going outside, and he took her phone. So they charged him also with false imprisonment, and then the tampering of a witness, basically preventing her from being able to contact the police. So he goes in, he's charged, he gets out on bond, and they're obviously separated. During the course of this separation, she contacts him. Now, she says that it was an accident and didn't mean to press that button, but two people with the same name, and I guess she had taken out husband or loved one, and two people with the same name, and she was texting someone. So ultimately, she texts him. They start talking, texting. Now, they're not supposed to talk, right? Because on a domestic violence case, you're not allowed to speak. So there's a no contact order in effect. So he violates the no contact order because even if the person who's the alleged victim contacts you, the judges tell you you have to hang up. If you're at a restaurant and they walk in, you leave. If that kind of thing. You're not allowed to use a third party to contact the person. So, needless to say, he violates a no contact order. Well, during the course of their conversation, she talks about the incident, and he doesn't really respond other than like, hey, I don't know what you're talking about, but not a lot. She's very emphatic, and he's sort of simple. Well, during that conversation, those text messages going back and forth, she gets upset because, again, the whole fight was over social media and whether or not he contacted or added someone to his social media account. So she believes that he's cheating on her. So she tells him, hey, F you, go cheat if that's what you're going to do, and we're done. Well, he doesn't take that, and he ends up calling her. Well, she says, don't call me. Now, there's already a no contact order. He's not supposed to call anyway, but he says, don't call me. Well, he starts to call her 63 times over I don't know, a 4 to 5 hour period. Just calling, leaving voicemail, hanging up, calling back. Just keep calling, because she's not picking up. Now, I don't know if her phone's on block or off or whatever, but there's 63 calls that come in. That's a lot of calls. So, because of that, they then charge him. When I say they, the state attorney's office then charges my client with an additional charge of aggravated stalking, because based on those facts, that would fit the definition of aggravated stalking, by continuously to call, harass, but threatening is not required. Even if he's calling and saying, I love you, honey, it still counts as aggravated stalking. So now what do? They charge him with the new crimes, and they revoke his bond. So when I'm hired, I'm going to see him at the jail, because he's not getting a bond. He violated the judge's order. The judge said, don't speak to her, don't talk to her. There was also a injunction hearing that she had where she had asked for no contact, so she got a restraining order. And just the charges, you're not supposed to contact. So he violated all of that. The judge put him in custody, no bond. So that's how I start the case. I do all the research I can. The family hires me. I do everything I can. There's literally, I don't know, 700 pages of discovery. There's medical bills. She goes to the hospital. During this entire course of time, she has mental illness, so she's Baker-acted, and a lot of things happen. So I get the discovery, the medical records, the mental health records, and obviously there's arguments. There's drugs involved. There's allegations that there's drug addictions on both sides, both the victim and possibly my client. There's pictures on social media with my client, with a firearm. There's text messages. When I say text messages, there's like, I don't know, a few hundred pages of text messages that prove that the contact, along with phone records from, whatever the phone carrier. So after I go through everything, I meet with my client, I explain to him, this is what I think. And there were 7 charges. And out of the 7 charges, I told him, look, if we go to trial, in my opinion, you're going to lose some of them. Now, I could have the best day. I could have a Michael Jordan day, and it's possible that, I could win all 7 charges. It's possible, but definitely not likely, right? So we go through everything. I mean, I go over his story versus her statements that she made to police. I go through everything. I speak to the prosecutor. We're going back and forth. And ultimately, I explain to him, listen, if we go to trial, the likelihood is more likely than not that we're going to lose on something. And if we lose on any of those charges, you're going to do time. And based on the charges, he was scoring just under 10 years. 10 years of Florida State Prison. Ultimately, in going through the case law, debating it out between myself and the prosecutor agreed that there was a shot, and that, it wasn't a perfect case for that prosecutor, either wasn't a perfect case for me. But out of the 7 charges, 4 of them, the prosecutor agreed to dismiss. So that meant that the 3 charges that my client would have to take a plea to, if he chose to take a plea, I don't want to say have to, because it was his choice, we could go to trial. But the 3 charges that were most likely to succeed, right? The aggravated stalking, by law, by the case law, by the statute, I honestly don't know how I could win it, because the judge said on the record, do not contact her. He received a copy of the do not contact order. He was on pretrial release, right? Meaning they told him he can't contact. There was a restraining order, that judge said, but he called and there's proof of that. He couldn't win that. That itself scored, right around 2 years. The second charge of strangulation, that's a debatable thing. The client did have some marks around the neck and chest areas, which could be contributed to that, but that's something also you could win on. But that was a 3rd-degree felony. And then the last charge was tampering with the witness. The allegation that when the police were outside dealing with something else and he took her phone and hid it, tampering. Those were the 3 charges that we settled on. Now, do I think on the strangulation case charge we could have gone forward? Yes. But I think that we also could have lost it, right? Because she has bruises and she has marks and all over her body. So they dropped the gun charge, right? The firearm, the aggravated assault with a firearm. They dropped the misdemeanor battery. They dropped the violation of the no contact order. And they dropped the false imprisonment. So the plea was what the best plea bargain after going back and forth, and we went back and forth over a couple of months. The best situation was 3 years of probation. I'm sorry, 3 years of 3 years of prison, convictions on those 3 charges, followed by 2 years of community control. Now that's a lot, and obviously a very difficult decision, because if they went forward on all of the charges, he scored just under 10 years, like maybe 4 months shy of 10 years. So if we went to trial and we lost, he was looking at a minimum of that 9.5 years, depending on what counts. But even with the 3 counts that we pled to, the ones that the prosecutor said, yeah, you know what, right, you're right, Foley, you have a legit shot at winning those. But even with just the 3 charges, he scored 6 years. So he was still going under the Florida Punishment Code of 3 years. He's allowed to have contact with his child, through the jail, through the prison. He's allowed to have visitation with his child. There were no child abuse charges or child endangerment charges. And ultimately, the client decided that that was the best case scenario for him. I showed him the upside, I showed him the downside, and I showed him sort of the middle. Discussed it with him, discussed it with his family, did a lot of back and forth bantering with the prosecutor. And the reason I'm telling you this, and the reason why I asked the client, Mr. Smith, to allow me to talk about the case, is because I feel like I'm always talking about the fight and the victory, but the reality, folks, is sometimes even with the fight, your chances of losing are so great that your risk of prison is so much higher. And I don't think as defense attorneys that we talk enough about the fact that even the hardest working attorney, even the top of the guy in his class, right? Even the guy that knows everybody, who knows the intricacies, the guy who's a great talker, who's articulate, who can act out these situations, that can talk to people, that can be motivators to jury members, even that guy or that gal can lose. And our job is to protect our client to the best of our ability, right? Is to protect our client not only from the system, but sometimes protecting them from his or herself, right? Because I have clients that come in, or potential clients that come in and say, I want a trial. And I read the facts and I go, buddy, based on your facts, and again, these are even facts from their own mouth. I go, if you were to say that on the stand, you're going to be convicted in like 5 minutes. So sometimes you have to look for other alternatives, diversion, probation. Obviously, the 2 most important goals that I've talked about in every case is to prevent prison and to prevent a conviction. And the reality is that I failed on this case in those 2 areas. But I gave it everything I had. My honest analysis to the client was the odds of me winning all 7 counts, with her being bruised, with her giving statements, with co-workers taking pictures of her bruises, of her family, having, video and taking daily photographs, her statements, the statements between the 2, the recorded, text messages. The odds of winning I didn't want to subject my client, but it was his choice. I didn't want to subject my client to trial and losing, because if we did that, he's really going to be looking at, I don't know, something like 60 years. The bottom was 10. The high was like 60. He's got 3. I'm not happy about it. I'm sure he's not happy about it. We shook hands. I talked to him. I even hugged him, and I said, you know, I'm going to pray for you. I want the best for my clients. You know, some people might watch this video and go, oh, how could you represent this kind of guy? You know what? I can tell you from my heart that there's a lot of good qualities about this guy. You can condemn the acts of the man, but you can't condemn the man. This man had a lot of good things about him. When I talked to him, when I first took the case, I was like, I don't know if I should take this case. I mean, it looked like possibly a legit domestic violence case, like a legit, where there was bruising, there were statements, there were, you know, all kinds of negative things that would imply that the alleged victim was telling the truth. But that's not how I roll. You know, the family talked to me. I liked the family. I trusted that they had belief in their son, and I wanted to do everything I could to prove his innocence. I couldn't, and that was with my best ever, you know, my best efforts, folk. I mean, yeah, they could have spent you know, a ridiculous amount of money, and I could have done focus groups, and I could have done practice trials, and I could have prepared it that way. But the cost-benefit analysis for a family to spend, you know, $50,000, $70,000, for me to really go all the way with the likelihood that I would still lose at least some of the charges, wasn't the smart move. But again, it was his choice. It wasn't my choice. I told them, hey, if you want to go to trial, we'll go to trial. If we have to do the focus groups and we have to do mock trials and we have to go through everything to do practice reps to see what jurors like, don't like. The problem is in my profession, people don't want to spend the money for that. You know, it's tough. So based on everything we had, the client decided that was the best choice for him. The most important thing out of the negotiation was that he'd be able to have contact with his child, that he'd be able to have visitation with his child, and we were able to secure that. So that's why it took me a day to go back and talk about this, because the charges were serious. The result, you know, again, the family thanked me, he thanked me, but the result to me was still a negative. I didn't do the two things that I go out of my way to do on every single case, is to prevent the conviction and to prevent incarceration. And I failed on both of those endeavors. And I'm truly sorry that I did. But I also can look, you know, into this camera and you know, look myself in the face, look people in the face, and say I did everything I could do, and I couldn't win. Just that aggravated stalking charge with all that proof scored prison, and we had a victim, an alleged victim, that wanted prison and wanted a lot of prison. So the prosecutor, you know, we went as low as, we got them to go as low as they would go. We got 4 out of the 7 charges dismissed, but I still failed. That's the reality. And I want people to know that's a reality when you hire a criminal defense attorney. We cannot guarantee a result. We will work hard. We will do everything we can. I treat clients like family. I've talked to this gentleman's family umpteen times, and I went through everything. I went through the 700 pages of discovery with him, you know, with his mother, with his father, with his sister, you know, to make sure that everyone was on the same page, so I could answer questions, so I could be there. The case is over, but you know, this gentleman is starting a prison term, and he's probably going to be there for about 30 months out of a 36-month sentence. That's the reality. That's the hardcore reality of what we do. I wish I could say I've gone 13 years and never lost. This is the the fourth person that's been sentenced to prison on my watch, but only the third that's actually gone. One of the four are out on appeal, and hoping that gets overturned. So 3 people I've had as clients in my 13 years have now gone to prison, and I'm not happy about it. So I'm attorney Roger P. Foley, letting you know the tough days, the tough weeks, the tough situations of my job, and that to know that no matter how great you love your attorney, he can't promise you the world. He can only promise you his or her best. Thanks for listening.